Okay, so you heard Anne-Marie testify how harmful that was when she heard someone try to say that Eric was on some sort of drugs when this crash happened, trying to blame him for everything, trying to throw whatever they could against the wall, see what'll stick. But here's the actual toxicology report. They tested for everything, every single thing. Amphetamines, barbiturates, benzodiazepines, buprenorphine, I'm not going to pronounce them all right, sorry. Cannabinoids, cocaine, fentanyl, methadone, methamphetamine, opiates, oxycodone, acetone, ethanol. Ethanol is alcohol. Methanol. They tested them for everything. Every single one of them, negative. Negative. A drug abuse screen is negative, and no ethanol, not alcohol, not any of the drugs, not nothing detected. He was clean. Stark contrast in this case between Mr. Echevarria and Mr. Collins. So when we go through the liability form, the second two parts, questions 1 and 2 are about Zaon Collins, but questions 3 and 4 are about Eric Echevarria. Easy answer on number 3. Do you find by preponderance of the evidence that Eric Echevarria was negligent? Answer is no. He didn't do anything wrong. Made a reasonable left turn. Mr. Collins was not in the intersection. Mr. Collins was not an immediate hazard because he was so far away. It's perfectly reasonable. But let's assume for a second I'm completely wrong. Like I'm just crazy. And Mr. Echevarria, you say, is partially at fault somehow. Anything Mr. Echevarria did not cause his own death. What it says there is, do you find by preponderance of the evidence Eric Echevarria Sr.'s negligence was a legal cause of his own death? Yes or no? Well, we already know what caused Mr. Echevarria's death. It was Zaon's high rate of speed, and he pled guilty to that, to the vehicular manslaughter, that his high rate of speed caused the death of another person. He actually said, yes, I'm pleading guilty. I agree. That's what happened. And now they're trying to get out of that. Say, no, he's not at fault. Nothing he did caused the death. So assuming for a second you find that Mr. Echevarria did do something wrong, answer to 4 is no. Do you find by preponderance of the evidence Eric Echevarria's negligence was a legal cause of his death? No. And then it says if you answered no to question 4, then you skip down to question 5 below. Oh, you then skip question 5 below and proceed to answer question 6. I'm sorry. Then you go straight to damages. You don't have to put a percentage in for Eric versus Zaon. No need for a percentage split up. So now we go on to damages, the second part. Did you want to take a break at this point, or you want me to keep going?
Yeah, does anyone need, you have about an hour left, right?
Yes.
Okay, we have about an hour left. Does anyone need like a quick bathroom leg stretch break right now, or do you guys want to keep trying to power through? Okay, seeing no hands raised, we're sure to go for another hour. Okay, go ahead, Counselor. Go ahead and continue.
Thank you for your patience with me. I
guys.
appreciate it. Thank you so much. Okay, so now we're on to the damages section of the verdict form. This is where you get to do justice. What amounts of damages do you award Anne-Marie Echevarria and Eric Echevarria Jr.? And then it has an A and B for Anne-Marie and a C and D for Eric Jr. And it basically says the same thing on both for Anne-Marie and Eric. A says plaintiff Anne-Marie Echevarria's grief, sorrow, loss of probable support, loss of companionship, society, comfort, and consortium, and damages for pain, suffering, disfigurement, and loss of enjoyment of life of the decedent from the date of the incident to present. And then it says it for the future for Anne-Marie, and then it says the same thing for Eric Jr. for the past and Eric Jr. for the future. And then it has another section at the bottom for medical expenses and funeral expenses. Now I'm going to talk about the medical expenses and the funeral expenses, but those don't even scratch the surface on the damages in this case. They don't even come close. It's not even the tip of the iceberg on this case, those numbers. So remember, preponderance of the evidence standard, more likely than not, just a feather more. Well, the good news is that standard applies also to your damages assessment when you get to assess the damages in this case. It says, whether any of these elements of damage have been proven by the evidence is for you to determine. Neither sympathy nor speculation is a proper basis for determining damages. And I want to talk about that sympathy word there. We don't want sympathy. We're not here for sympathy. We're here for an understanding of what happened to Eric Echevarria, an understanding of how this has affected his family, what this has done to them. Very different than sympathy. Having an understanding is not synonymous. It's not equivalent to sympathy. And then the second part of the instruction says, however, absolute certainty as to the damages is not required. It is only required that plaintiff prove each item of damage by preponderance of the evidence. So that standard also applies to damages. And this is the estate damages. This is where the three things come in. And perhaps I should explain this first. Technically, there are three plaintiffs in this case. There's Anne Marie as the personal representative of Eric Echevarria Sr.'s estate. Okay. And then there's Anne Marie as an heir of Eric Echevarria Sr. And then there's Eric Echevarria Jr. as an heir of Eric Echevarria Sr. So Anne Marie is actually filling in two roles, the personal representative of the estate and an heir of Eric Sr. So this says, plaintiff Anne Marie Echevarria is the personal representative of the state of Eric Echevarria. Damages recoverable by the personal representative of the decedent on behalf of the estate include, 1, any special damages such as medical expenses which the decedent incurred or sustained before his death, funeral expenses, burial expenses, etc. So we got those. Those are numbers that are in. I'm going to talk about them in a second. Don't even scratch the surface. But then 2, any penalties, including but not limited to exemplary or punitive damages that the decedent would have recovered if he had lived. Punitive damages against Mr. Collins. And we'll talk about that in a second as well. So first of all, the medical expenses. These are unrefuted by the defense. Numbers, they may be big numbers for medical expenses, but again, they don't even come close to scratching the surface for the full extent of the damages to this family. $99,008.91 for all those medical expenses. And I have the exhibits there. Exhibit 1, Exhibit 3, and Exhibit 4. Couldn't get this the Southern Highlands medical bills or records because for some reason they had him under a doe, and they couldn't. Every time we do a request, we couldn't find him in their system. But these are the medical expenses that Anne Marie received. And then the funeral expenses. This is Exhibit 6, Palm Southwest Mortuary. $9,138. Just a fraction of tiny fraction of what the real damages are in this case. So I filled those in. But now there's an instruction that talks about what the heirs get to recover. So we address the estate. State gets the medical bills, funeral expenses, and punitive damages, which we'll talk about later. And now the heirs get what this instruction talks about. It says each heir's loss of probable support, companionship, society, comfort, and consortium. That's number 1. And then it explains how you determine number 1, what you can consider. In determining that loss, you may consider the financial support, if any, which the heir would have received from the deceased except for his death, and the right to receive support, if any, which the heir has lost by reason of his death. Then it says the right to receive support from another is not destroyed by the fact that the former does not need the support, nor by the fact that the latter has not provided it. You may also consider A, the age of the deceased and the heirs. That's why we had Ms. Larmore talk about their life expectancies. B, the health of the deceased and of the heirs. Well, we know Eric Echevarria Sr. was extremely healthy. He was fit. Everything indicates he was going to live a long time, long, healthy life. If someone didn't come along going 88 miles an hour and slam into him and throw him into a wall. D, the respective life expectancies of the deceased and of the heirs, and Eugenia Larimer talks about that. D, whether the deceased was kindly, affectionate, or otherwise. And you've heard lots of testimony about that. This was a kind person. He treated everyone with respect, no matter anything. The kids loved him. Everyone loved him. He was generous. E, the disposition of the deceased to contribute financially to support the heirs. He had a stable job. He was working hard. He was a hardworking gentleman that cared for his family and took care of them. F, the earning capacity of the deceased. You heard about his earning capacity, how much money he made. The economists talked about that as well. His habits of industry and thrift. And then any other facts shown by the evidence indicating what benefits the heirs might reasonably have been expected to receive from the deceased had he lived. And then we go on to the number 2, that the heirs may recover. This is important. Any damages for the pain, suffering, disfigurement, and loss of enjoyment of life of the decedent. Pain, suffering, disfigurement, and loss of enjoyment of life. And you heard testimony from Dr. Hirschfeld about the pain and suffering Mr. Echevarria would have experienced. And we know, luckily he didn't suffer for very long, but he did suffer.
Doctor, would Eric have experienced any pain and suffering as a result of this crash?
So I think he probably would have, but the amount and time that was present, I can't tell you.
Okay.
And then he goes on to explain that people, when they're in Glasgow Comas 3, when they're suffering from those type of injuries, we know that there is some type of suffering going on. There is some type of pain being experienced. Here it is.
So medical literature has dealt with patients in a coma or with GCS-3 scores. When a patient is unconscious, they cannot verbally or by way of withdrawal or grimace or other measures respond to painful stimuli. That doesn't mean they're not having painful stimuli. And so the literature advises emergency room doctors and intensive care doctors on how to manage pain in comatose patients, because it's universally felt that some level of pain is felt. And so we are trained on how to manage that pain. That's the best I can say.
You get to decide whether you put a number in for pain and suffering or not. Ultimately, no one wants to be in that position. These are horrendous injuries. He didn't die right away. There would have been some level of suffering. The next thing is the disfigurement. You get to put in a number for the disfigurement of Mr. Echevarria Sr. Emery, close your eyes for a second, please. Don't look. We're done, Emery. It was terribly disfigured from this crash. The same mechanism that caused these blunt force injuries obviously caused his death and caused his disfigurement. The mechanism is this crazy high rate of speed on our roadways that Mr. Collins was going. The number for disfigurement, I don't know if any number does it justice, but it needs to be a big number. Nobody wants their family member to end up like that. Oh, the next thing is loss of enjoyment of life of the decedent. Loss of enjoyment of life. You can use your common sense to decide what loss of enjoyment of life is. the pursuit of life, liberty, and happiness. They took that away from him. That has real value. And you as jurors get to show through the number you put in your verdict that has real value in our community. And then the grief or sorrow suffered by the heirs. That grief or sorrow. It's a wound on their hearts. An open gashing wound. Wound that will never heal. Every time Anne-Marie has to go by that wall, she thinks of Eric. She thinks of that day and what happened. Eric Jr. has a picture of his dad in his room on his wall. Sorry. This man was not an afterthought to this family. This man was central, pivotal, key to this family. The next instruction I want to talk about. No fixed standard. It says no fixed standard exists for deciding the amount of physical and mental pain, suffering, and loss of enjoyment of life damages. No fixed standard exists for deciding the amount of disfigurement. No fixed standard exists for deciding the amount of grief or sorrow or the loss of companionship, society, comfort, and consortium. Nor is the opinion of any witness required as to the amount of such reasonable compensation. You must use your judgment to decide upon a reasonable amount based on the evidence and your common sense. We talked about the value of life, value of the grief, sorrow, pain, suffering, loss of enjoyment of life, and jury selection. It's priceless. Common sense tells us it's priceless. That's why your number has to be commensurate with what they've dealt with here, what they've experienced, what this family has gone through, what they had to endure because of this. So you decide the standard. You get to say, what is being disfigured like this as a result of someone going 88 miles an hour on the roadway? What is it worth in our community? What is having this type of suffering worth in our community? What is this type of sorrow that's never going to go away, that's going to eat up this family? What is that worth in our community? You get to decide. It's testimony from Jason.
Emotional standpoint. We're talking about the ceilings.
We're trying to get there, and he completely shut down. Thank you.
Thank you. Okay, I mean,
Well, yeah, he completely shut down. I don't think he wanted to. I mean, I don't know if anybody really accepted or had to deal with that grief at such a young age, but yeah, he just shut down mentally, and it was hard to get him to talk about anything.
it was hard. The last thing I want to ask you. About your mom, knowing your mom, the way you do, everything you observed before and after Eric passed away. Is your mom the same person she was before Eric died?
She tries her best for us and her, our family, but she's not. She's always had like this glimmer in her eyes and was so outgoing and never anxious, never scared to take on anything. And just seeing her, down, and she's not the same person as she was before Eric passed away. She consulted him a lot for a lot of things, and we can only talk to someone, but that was her partner, so she was really
have like that person to talk to. So it's been rough seeing her, like I said, she tries her best and she does what she has to do and she's, for family, but, she is not the same as she was, that same outgoing person.
And you heard testimony from Moses.
When was the,
Sorry, this is Maria, I apologize.
when was the last time you spoke to Eric? Eric Senior?
The last time I spoke to Eric was 2 days before my daughter's birthday. My daughter's birthday was December 29th. And he died the next day. And I spoke to him on the 27th. Because I was telling him I had a little financial struggle with getting my daughter a birthday cake. And without hesitation, he just sent me the money. He said, "Here, don't worry about it." And that's the last time I spoke to him.
And that was, you said 3 days before he passed?
Yeah, yes, 3 days before he passed. I miss him very much. We all have no idea what this small town does to our family.
Here's Moses.
What do you remember about your interactions with your mom in the time period immediately after Eric passed away?
She lost all that life. She lost all that life. It was weird to see her go from such a happy place to immediate like shock. And I think that was, what I experienced with her was that shock, I don't want to say lifeless, but it was almost lifeless. She didn't have her, that's the best way I can say it. She didn't have her light anymore. Like she reverted, she didn't revert back, but you could just tell she went to that unhappy place again, where I think she thought for a long time she wouldn't be.
And now that we're past 4.5 years since Eric Senior died in the motor vehicle crash, how would you describe how your mom is today compared to how she was back then?
I don't feel like much has changed as far as her getting back to that like spot. It's just, she has to look at Eric every day and they look almost identical. So I don't think I know there's never a day that goes by where she doesn't think about the accident or think about what's happened or, what the future is gonna look like for, little Eric or for herself. And so I don't think she really ever, I still honestly don't, I know she hasn't recovered from it yet.
When I said in opening that Eric Senior was a knight in shining armor for Anne Marie, I don't think I was exaggerating. And this is Rigo right here.
How would you describe her in terms of the type of person he was at the around network?
Very seriously, he was one of a kind. Eric was loved by everyone. Talking about staff, teachers, students, my coworkers. He was that type that, he had words for everybody. He had your time. He had your attention. One of a kind. One of a kind.
So, putting those numbers in there, but before I talk about the total number, I want to tell you a little story. Put the money we're asking for in context. There's a art museum, and it's late at night, and there's a security guard named Jimmy who works in the art museum. And there's also a $100 million painting in the art museum. It's a classic. It's a very important painting. And the art museum catches on fire. Jimmy's stuck inside. Can't get out. The $100 million painting is stuck inside. Firefighters come. And the firefighters ask, what's inside? And they're told there's the painting. It's worth $100 million. And Jimmy. Who do we want them to save first? Who do we want them to get out first? Who do we want them to focus on? Jimmy or the $100 million painting? Every single time, human life is worth more. Tell them, everyone in that situation says, get Jimmy out first. Worry about the $100 million painting later. When we came to this trial, based on everything you saw, based on everything we knew, based on who Eric Sr. was, we wanted to ask for $100 million. Really did. But I had this fear that you would think I'm being unreasonable. You would think we're all being unreasonable. So we picked a number that we think is reasonable based on everything you saw. And I talked about the range in jury selection, $25 to $35 million. And now the evidence has come out. I think it's clear that the top end of that range is more appropriate. The $35 million for the total number. And ultimately, we ask that you not give a penny less than this in your total number. $35 million. And those categories right there for Plaintiff Anne Marie's grief, sorrow, loss of probable support, loss of companionship, society, comfort, and consortium, and damages for pain, suffering, disfigurement, and loss of enjoyment of life of the decedent from the date of the incident to present. And then the same thing for Eric Echevarria Jr. Eric Echevarria Jr.'s grief, sorrow, loss of probable support, loss of companionship, society, and comfort, and damages for pain, suffering, disfigurement, and loss of enjoyment of life of the decedent from the date of the incident to present. And then the future, that same thing for the future. That's not easy to fill out, splitting up the money. But the bottom line is the total number, not a penny less than $35 million is what we think is reasonable. The truth is, you can give more if you want. Perhaps the $35 million doesn't do justice for what you've seen. But at least it'll deliver some sense of justice. Not a penny less than $35 million will deliver some sense of justice for this family. So I'll leave how to fill out A, B, C, D to you. But that's the total number we're looking for. Not a penny less than that. Here it is, A, B, C, and D. And this is a quote I really like. It says, the price of anything is the amount of life you exchange for it. Pertinent quote, please. And this is The Economist talking about their life expectancies.
Do you know the remaining life expectancy for Eric Sr.?
I did.
And what was that number in your calculation?
He had, based on his age and the fact that he was a male, he had approximately 28.9. I maybe 28 for sure, plus point something years remaining to approximately April 2049.
Lots of life left. Lots of time left. If someone didn't just drive recklessly 88 and a 35 and crash into him, throwing him on top of a wall.
And what was your result for the remaining life expectancy for Anne Marie?
I believe she had 29 point something years to, I couldn't give you the month, but to 2050. So she was expected to outlive Eric Sr.
Lots of time left for them to enjoy together. You heard about her dreams a little bit. In retirement, go live on a beach somewhere, hang out in the sun. Excuse me. Obviously, that's never going to happen. This is a quote I really like from Steve Jobs before he passed away. It is really clear the most precious resource we all have is time. They took that away from him. They took away his time. They robbed this family of their time with from the patriarch of their family. So, like I said, not a penny less than 35 million. How you come to it, truth is, it's not as important as the total number. Because we have to make sure that we say life is valuable. If you disfigure someone, if you cause serious suffering, if you cause serious grief that's going to last a family for the rest of their time on this planet, because you are endangering the lives of other people on our roadways, we are going to make sure we write in a number that accounts for all of that. That's why we're asking for that number, not a penny less. So, the last question you're tasked with. Does the jury find by clear and convincing evidence that punitive damages should be assessed against defendant Zaon Collins on behalf of the estate of Eric Echevarria? Because you saw that early instruction that talked about the estate can recover three things: medical expenses, funeral expenses, and punitive damages. Here's the punitive damages question. So we're going to ask you to put yes in this. I'm going to tell you why. So the first thing I want to go over is this clear and convincing evidence standard. We've talked about the preponderance of the evidence standard. Everything you evaluate in this case is based on the preponderance of the evidence standard, except this one thing, this one tiny thing, which is the punitive damages. Clear and convincing evidence is that measure or degree of proof which will produce in your mind a firm belief or conviction as to the allegations sought to be established. It is an intermediate degree of proof, being more than a mere preponderance, so it's higher than our preponderance of the evidence standard, which is just above 50%, but not to the extent of such certainty as is required to prove an issue beyond a reasonable doubt. Remember, we talked about beyond a reasonable doubt up here. The criminal case against Zaon, that's all beyond a reasonable doubt. So it's somewhere in between is the standard how you assess punitive damages. Proof by clear and convincing evidence is proof which persuades you that the truth of the contentions is highly likely. And then it explains at the bottom, the only thing that needs to be proven by the plaintiff to the clear and convincing evidence standard in this case is the punitive damages, isolated just to the punitive damages. And this is the instruction on the punitive damages. It talks about the law. It is unlawful for any person to drive or be in actual physical control of a vehicle on a highway or on premises to which the public has access with an amount of any of the following prohibited substances in his or her blood that is equal to or greater than. And then it goes into detail on marijuana, what the substance is. So, just like with alcohol, if someone is above a certain level, it doesn't matter whether or not we can tell they're impaired. They're per se violating the law. They're, as a matter of law, above the legal limit. Marijuana is the same thing. If someone has a level of marijuana in their system above these levels and they're behind the wheel of a car, they are per se violating the law. There's no exception. You can't say, oh, well, I wasn't intoxicated, or I wasn't impaired, or I can drink 100 beers and walk around just fine and drive a car just fine. No, no, no. You can't get behind the wheel. You can't be above the limit. That's the way the law works, just like with alcohol. So let's look at it. Above is the toxicology results. Below is the law. Now that you get the law. And I think I switched these in my opening statement, so I apologize for that. But now we have the law. Can't be above 2 milliliters, nanograms per milliliter of delta 9, right? And what was he? He was 3. He was above it. And okay, so there's an error rate in the toxicology results. For the delta 9, the error rate is 0.6. So even if we put it at the bottom end of the error rates, that would be 2.4. He's still above the legal limit. Either way, this is, as a matter of law, he is violating the law on him getting behind the wheel with marijuana in his system. Then we have the marijuana metabolite. And defense pointed out, well, the marijuana metabolite doesn't actually, it's not an active substance, so it doesn't actually impair someone. That's not the issue here. The issue is, this is a two-part test to make sure if someone's above one of them, they're over the limit. He was above the limit on marijuana metabolite. The limit is 5, and he's at 32.4. So he's, what is that? 6 times? Quick math. Over 6 times the limit on that one. No exceptions. We're not going to create a standard in our community where if someone says, oh, I can drink lots of beer, but I'm not impaired, even if I'm over the legal limit, so I shouldn't get a DUI. No. He's over the legal limit. There's no exceptions here. And this is important because Dr. Raymond Kelly talked about how him being over the legal limit is not an opinion. It is a fact. There is no getting around it. It is a fact to over 99% probability that he was over the legal limit. Here it is.
In your scenario, and regardless of the degree of impairment, is it your opinion that Zaon Collins was in fact driving in excess of the legal limit for both THC and marijuana metabolite at the time of the December 30th, 2020 crash?
Yes, but that's not an opinion, it's a fact based on this test. If you accept the results of the test and you accept what the law said at the time, then it's just a fact that he was above that.
Well, at any point that you assess the likelihood that Zaon Collins' blood test results, as we have up on the screen, formed and processed by Las Vegas Metro Police, were somehow inaccurate and that he may not have actually been above the legal.
Yes, it did.
And what did you determine in that regard?
Remember, I mentioned that the legal limit for THC itself was 2 nanograms per mil at the time, and currently it is still the same. And his result was 3.0. There's a figure on this report, 0.6, which is the uncertainty that the lab calculated. And I utilized that figure to estimate what was the probability that the actual result, if the test came out 3.0, what was the probability that it actually was 2.0 or less? And I came out with that probability being 0.12%.
0.12% chance he was not over the legal limit, which means, what is that, 99.9 something? He's over the legal limit. It's well beyond the clear and convincing evidence standard. This is the only thing we need to prove by clear and convincing evidence, but it's well above that. So then we go on to the rest of the instruction. It says, if you find the plaintiff is entitled to compensatory damages for actual harm caused by defendant Zaon Collins' breach of obligation, you may consider whether you should award punitive damages against defendant Zaon Collins if the plaintiff proves, 1, defendant Zaon Collins willfully consumed or used a controlled substance such as marijuana, knowing that he would thereafter operate a motor vehicle. This is where their gummy story comes in. The gummy story where Zaon couldn't even say whose birthday party he was at, couldn't say who told him to eat the gummy. He couldn't even give a single witness to come in here and corroborate that this birthday party where he ate a gummy ever actually existed, as opposed to it being a figment of his imagination that he created in order to get out of his criminal prosecution on the marijuana intoxication. It's a story he created. You can tell that from the evidence. It's not real. And it's not consistent with the toxicology. Toxicology doesn't lie. That's the thing. Here's the toxicology rule. This is what Raymond Kelly said.
And I believe you said that these, among the reasons why these two compounds are tested for is because they lend some insight into the recency of use. Do I understand that correctly?
Correct.
So when you look at these two results together for Zaon Collins, what do these results indicate to you, Dr. Kelly, from a toxicological standpoint?
Recent use of marijuana, for example, these would be pretty typical results of somebody smoked a joint within a few hours of the time the sample was taken.
Is your last statement specific to smoking marijuana only as opposed to other forms of ingestion?
Other forms of ingestion pretty much can be the same time frame.
Consistent with him smoking marijuana that day. So is it consistent with him eating a gummy with marijuana 2 to 4 days before the crash? Well, let's see what Dr. Kelly said about that.
Now, are the results of Mr. Collins' post-crash blood test at the urine screening is a 10 consistent with someone who consumed 2 gummies 2 to 4 days prior?
No.
A story created to try to get him out of the prosecution. Try to get him out of the DUI part of this case.
When you say Mr. Collins' scenario, just to be clear, are you saying that if we were to take Mr. Collins at his word that the only time he used marijuana prior to the crash, he was eating 2 gummies 2 to 4 days prior, that you would have expected that THC to have passed through his system by the time he was tested 2 to 4 days later?
Correct.
This is why they couldn't proceed in the DUI charge to beyond a reasonable doubt. But you, in this case, for the punitive damages, you get to assess it at a lower standard. You get to assess Zaon's credibility also. You get to assess, well, does it meet the clear and convincing evidence standard, which is somewhere in between preponderance of the evidence and the beyond a reasonable doubt, somewhere in the middle. And yes, the toxicology doesn't lie. He smoked the day of the crash. That's what the toxicology says. The gummies would have been out of his system. He made up the story. The second part, all we need to prove is that defendant Zaon Collins thereafter caused actual harm to the plaintiffs by operating a motor vehicle in violation of this law. And the law, again, is you can't get behind the wheel when you're over the legal limit. We know he was over the legal limit. It's a fact. And he injured and actually killed Mr. Echevarria. So the purpose of punitive damages, to punish a wrongdoer that hereby harms the plaintiff and deter similar conduct from others in the community. It's a deterrence. We need to make sure people know they can't do this. This is not right. We're not going to stand for this behavior. So the credibility instruction. It says the credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to observe the matter to which he or she testified, the reasonableness of his or her statements, and the strength or weakness of his or her recollection. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his or her testimony which is not proved by other evidence. You get to decide. This is up to you. You get to decide whether Zaon is truthful or not. You get to make that assessment. Remember what Zaon said when the crash happened? He said he went to check on Eric. Checked on him. Well, we've got a very credible witness who was at the scene who says otherwise.
Or get out of this vehicle, is that right?
Correct. Right away, ran out of the car. Like, Yeah.
And at any point, did you see the driver of the black car go over to check on or to get close to where the driver of the white car was positioned?
Not at all.
Okay. You get to use that to assess Zaon's credibility. Is he truthful or is he untruthful? This is one thing I want to bring up real quick, okay? This says not to blame third parties, okay? If a jury determines the plaintiff is entitled to recovery, it shall return by general verdict the total amount of damages the plaintiff will be entitled to recover from this accident. Thus, you are not to consider the negligence and or fault of any person who has not been made a party to this case. I know there was a question about the paramedics and whether it normally takes them that long to get someone out of the car. Paramedics are just doing their best job. They're the best they can to try to save Eric. We can't blame the paramedics. And the law says we can't blame anyone else for this crash. Just look at the people in this case. People in this case are Mr. Collins. And now this instruction is extremely important because it addresses a lot of your concerns, a lot of things that some of you said in jury selection. You are not to discuss or even consider whether or not the plaintiff was carrying insurance to cover medical bills or any other damages he claims to have sustained. You're not to discuss or even consider whether or not the defendants were carrying insurance that would reimburse them for whatever sum of money they may be called upon to pay to the plaintiff. Don't think about whether or not defendants have insurance. Doesn't matter in this case. The law says it's not something for you to consider or even care about. Whether or not either party has insurance is immaterial. It should make no difference in any verdict you may render in this case. So don't talk about insurance. Don't think about insurance. It makes no difference to your results. And then the last part, perhaps the most important. This is important because I know in jury selection we talked about some people who had concerns. Well, how do they collect that money? What's the point of this if they can't even get the money? Well, first of all, sometimes things need to be done as a matter of principle, whether they can collect the money or not. But this instruction is important because it tells you as jurors doing your duty not to worry about whether or not the money is collectible or where they can get it. It says whether or not the verdict you render is collectible or the source or from whom the verdict may be collected also is immaterial and should make no difference in any verdict you may render in this case. Don't think about, well, that's too much because they'll never be able to collect that money. Don't think about that. The law says that's not something for you to consider, fortunately. So it doesn't matter that Zaon's an individual. Doesn't matter whether we can get this money or not. You as jurors are assessing the case, the facts, and the damages. You're writing in the number that's the right number, whether Zaon is an individual or a corporation, or whether we can collect that money or not. It doesn't matter either way for your purposes here. That makes sense. So please, I ask that you follow the law and don't worry about whether or not we can collect the money. And the last instruction says, it is your duty as jurors to follow these instructions and apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in these instructions. Sometimes we disagree with law. It happens. But jurors are the enforcement mechanism of the law. You get to enforce the law. So whether you agree with it or not, I ask that you follow your oath, and I know you will, as the good jurors you have been, and the good jurors you will be going forward. You follow the law, and make sure you enforce it the way it's written. And the last thing I want to say is, the news has been following this case. Sometimes verdicts make it in the news.
Okay, we can approach. Why don't you take it down for now? Okay. I'm just gonna ask the jurors to disregard the immediate last statement that was made before everybody approached the bench. And counsel, you can go ahead and continue.
Thank you, Your Honor. Based on the evidence you heard in the case, based on everything you heard about the conduct, about the damages, about the injury, about the suffering, about how amazing this man was, passed away, how helpful he was to others, how much he cared, how important he was to his family. And based on the evidence that you heard about the defendant's conduct, I'm going to ask you, just based on that evidence, I want you to send a message. You get to send a message through your verdict that we won't stand for this type of conduct. Last but not least, I want to thank you for your time. Thank you for listening to me. Thank you for bearing with me. Thank you for your patience. If I didn't say hi to you in the hallway, please forgive me. I'm a friendly person. I'm just trying to follow the rules and make sure I don't violate any rules. Thank you so much.
Okay. At this time, we're gonna take a lunch break. There should be lunch in the jury room back there for you. I have to read you the instruction one more time before we take that break. You're instructed not to talk with each other or with anyone else about a subject or issue connected with this trial. You're not to read, watch, or listen to any report or commentary on the trial by any person connected with the case or any media or information, including without limitation, newspapers, television, internet, or radio. You're not to conduct any research on your own relating to this case, such as consulting dictionaries, using the internet, or using any reference materials. You're not to conduct any investigation, test any theory of the case, recreate an aspect of the case, or in any other way investigate or learn about the case on your own. You're not to talk with others, text others, tweet others, Google issues, or conduct any other kind of book or computer research with regard to any issue, party, witness, or attorney involved in this case. You're not to form or express any opinion on any subject connected with the trial until the case is finally submitted to you. Okay, right now it is 12:25. I was thinking about giving you guys 45 minutes to go relax and eat your lunch back there and refresh a little bit before you come back for the rest of the closing arguments. Does anyone think they're gonna need more than 45 minutes? If so, raise your hand. We can give you a full hour if you need it. If somebody needs to do something else or they were planning on doing something else during this break. Okay, with that being said, then I'm gonna release you now at 12:25, ask you to come back. Hold on, let me do the math. I believe 1:10. So if you can plan to come back at 1:10 or just make sure you're in that room 1:10, like I said, there's lunch back there for you right now. Because we are allowed to buy lunch for you on deliberation day, which we do expect you to be deliberating today. Okay, we'll see you guys back here at 1:10. Thank you very much. The door's closed, right? Yes. Everybody can go ahead and be seated. Before we take our break, does anyone want to make any additional record or clarify anything we did at the bench?
I don't think so, Your Honor, not the plaintiff.
Defense? Okay.
No, Your Honor.
Okay, thank you. So we'll be on a break too. If, just in case you guys think you have something more, why don't we plan to come back at 1 o'clock? And then if we want to do anything more, let's say 1:05, that gives us 5 minutes if there's anything before they come back. Okay, thanks, we're on a break too.
Improper, objectionable.
Okay.
It's up to you. I mean,
So we can pull it up.
we can do it now if you
Yeah,
want.
let's put up a thing. They're just hanging out and having lunch, right?
Yes, Your Honor.
So,
I think the first is there's some slides where they show the picture of what $50,000 looks like. They have wads of cash on the screen.
Yeah, we can pull that up.
I think this is prejudicial. The next one also. You can see it.
Are you filling it like this? Is that the plan?
That's as I'm talking.
I think it's prejudicial, it's improper, it's it distracts the jury, it's jury nullification, distracts the jury from the issue at hand, which is what's the right amount of money to award, not what does $35 million look like, what does $35,000 look like. I think it causes juror confusion. I think it distracts from the issues at hand. Anything else? Jury nullification.
Under the Evans, Wyu versus Tate case, 138 Nevada, 423. The court in that case held that the defense attorney's arguments during closing as to putting money into context was not an improper ability to pay argument and did not encourage jury nullification because it did not implore the jury to disregard the evidence. So in that case, the attorney in his closing was trying to put into context the amount of money that the plaintiffs were asking for, and did so by a variety of methods. And the Supreme Court upheld that that was not an ability to pay argument under the Leochi case and affirmed the district court ruling on that issue.
May I respond, John?
Yeah, just a second, let me look up, in that case, I don't have like,
Next copy here, Judge.
I have it open, but I don't have a lot of clarity with that case, just give me a second. Sure.
It's okay, the part that I'm referring to. Let's see.
What's the purpose of this? How are you gonna use it?
Sure, so I need the jury to understand what the context of $35 million is. $35 million is a lot of money, and it's very hard, and studies have shown that it's very hard for people to understand just how much money that truly is. So having them presented with visuals or explanations, putting that kind of money into context. For instance, in the Tate case, the attorney talked about the average family making $50,000 a year and saving $50,000 a year, and it would still take them 20 years to save $1 million. That was permissible argument because it puts the amount of money into context.
Tell me when I can respond, John.
Are you done?
Sure.
Okay. You guys, do you have anything to say?
No, Your Honor, other than just to add on, this is closing argument. Gives juries an understanding. I'm assuming that all the little dollar signs add for $35 million.
That's the intent.
And I think that would have been like the objection. Stuff up there that doesn't.
I don't know, do every single one of those dollar signs actually add up to $35 million? They're actually counted?
Yes.
Okay,
Thank you, Your Honor.
okay. Okay, response.
You know, Vinny.
Your Honor, this is distracting from the issues at hand. The issue at hand is not what does $35 million look like when you lay it out. The issue is what is the right amount to award for pain and suffering, loss of the sorrow, the discomfort, the disfigurement, all those other things. I think this is also a golden rule argument. So I'd like to place a golden rule objection.
How's a golden rule argument?
It distracts from the issues. I think golden rule and jury nullification are blend together. I think it distracts from the issues at hand, which is what is the right amount of money, not what does $35 million look like? What does $35,000 look like? So putting it all up on the screen and having it go across the screen like that, it's prejudicial. It has nothing to do with the arguments in the case. It has nothing to do with the evidence. It has nothing to do with what's the appropriate amount to award. It doesn't place the money in context. All it does is try to make the money look like it's a ridiculous amount. If they want to argue that, they can argue that based on the evidence, this is too much money, but showing it on the screen, this is prejudicial. It's inappropriate. It's golden rule violation, jury nullification.
Okay, so you don't think it's a problem for them to put it in context and to discuss how much money that actually is? You just think the method by which they're doing it is inappropriate? Am I correct?
Well, I want to be clear. In Tate, the Supreme Court said there was no golden rule objection made. I am making golden rule objections, so the distinction between Tate and here, one distinction is I'm making the objection based on golden rule. The second thing is Tate, they put it in.
The golden rule is like, you can't ask any of the jurors to put themselves in the position of any of the parties. So I'm not following your argument. Like, how is this asking the jurors to put themselves in the position of any of the parties?
Well, that's classic golden rule. I think there's also Leoche is typical golden rule. Leoche talks about the golden rule and
Okay,
distraction from the issues in the case. That's what jury nullification would be. And I think that blends in with golden rule, Your Honor. I think what's going on here is showing a bunch of cash on the screen. Has nothing to do with the evidence in the case. Has nothing to do with what has been discussed throughout the trial. It does not put the money in context by showing a bunch of cash on the screen. It's prejudicial because it makes it look like, oh my gosh, look at all this crazy amount of money. This is improper, Your Honor. Those are my objections.
anything more to respond?
I stand by my statements already. I don't believe it's a Leoche violation and it's not a inability to pay argument. And it is not golden rule.
Okay. You want to say something else?
In Tate, there was no showing, nothing in Tate says they showed stacks of money on the screen. So I don't know how Tate actually applies to what she's trying to do here. She's trying to actually show stacks of money on the screen, which has nothing to do with what the council did in Tate.
Well, I don't have to mimic what the council did in Tate. He was discussing the value of $1.
Well, how does showing that slide go to the value of $1?
Because we have another slide that council has objected to that breaks that down a little bit further, if you want to put that up.
Yeah, let's put the slide too. I mean, how long do you plan on having that slide with the monies? the
Very
money
briefly.
So I have a different objection to this one.
Okay,
My objection is this one is it's conflating two things, Your Honor. How long Eric would have had to work, the homes, everything else, that would only apply to economic damages. That has nothing to do with the non-economic damages here. They're trying to put the non-economic damages in the context of economics of how much someone would have made, how much the plaintiff would have made if he survived. So it's conflating two different issues. So it's.
okay, I do have some questions actually about, okay, okay, go ahead, actually, never mind, finish.
It's gonna cause juror confusion.
Cause I have a different line of questions actually from this.
So.
And
Yeah,
your
it's gonna-
objection is that this causes juror confusion, right?
That's my primary objection.
Okay.
Your Honor, and I wanna reiterate that in Tate, the Supreme Court specifically said that a golden rule objection was not made. I'm making a golden rule objection to this one as well.
Okay, I'm a little more bothered by a couple other things when we get to this slide. What is the average cost of a house in Nevada and who gave us that information? What is the cost of Eric Jr. going to college and who gave us that information? So I do see how this can cause confusion. What's the cost of a cruise and who gave us that information?
Just it's argument, it's broad estimations. I don't think it needs evidentiary support to know that for the.
No,
jury
but
that
what's the
it's
cost of a
fine.
cruise? I don't know what the cost of a cruise
For a
is.
cruise around the world, anywhere between $80,000 to $100,000.
Okay, but I don't know. The first one I'm assuming is off of his income, off of the actual economist. So the first one you can have. The last three, I don't, what's the average cost of a home in Nevada? I don't even know that.
It's
You know it, Mr.
500,000.
Johnson? What's the
Oh.
average cost of a home in Nevada and how do you know that
Well, I
information?
don't know it. I think that maybe a compromise, you could buy 700 homes at X in Nevada. You could send.
Well, that's not what this slide says though.
Well, but it could be offered.
Okay, because he's saying it's causing juror confusion, and I'm confused looking at some of this too. The first one, like I said, I'm assuming the first one is a math calculation based upon what the economist said his his earnings was, or what his annual earning was, which I forget what his annual salary was.
About
Okay.
$60,000 a year.
Yeah,
We
and
could
I don't
put-
even know, do you use the full package that he has, or was that just his,
We use the full.
the full package? Okay, so the first one, I can see where you got it. If you want to put it in perspective, fine. The first one was fine. The other three,
Well, then how about we do, buy 70 homes for $500,000? Instead of saying the average home cost. You could buy this many homes for $500,000. You could buy this many cruises for $100,000.
is that what the average house of average cost of a house in Nevada is, $500,000?
Just about.
I have a different objection to that, Your Honor.
Okay, what's the other objection to that?
All right, so this is the issue. They can't talk about what my clients could use the non-economic damages for. Economic damages are to replace economic losses, but non-economic damages, you can't say, well, they could do this with the money. They could do that with the
But
money.
you already compared your client to, or you compared Jimmy, okay, to a like $100 million painting, right?
Correct.
Okay, like a one of a kind, that's the impression I was getting, that you were trying to make a one of a kind. And I think you get to say that as a counter, that like, we're not talking about this, we're talking about one of a kind human life here, and you did go into that. I think they get to put the money in perspective. I'm a little bothered by how some of the perspectives are being presented here, because I don't know how some of the information comes in. And that's my worry too, because I do think that's confusing.
Okay, so I think it solves your issue. We could pull that back up. It solves your issue, I think, if I'm understanding it correctly, Your Honor. If I say, Eric would have to work this number of years because we do have that data, but then from there, if we just kept it general, you could buy X number of houses for $500,000. You could buy X number of this for this amount of money, and then that
Can you
way
put
I'm not
the
making.
yeah, let's go back to the $50,000 slide. Can you put that one up for a minute so I can take a look at it? Okay, and this one has how many $100 bills in each stack?
$10,000 is each stack.
Can't even tell how many $100 bills are
So there
there.
should be $100 bills in each one of these stacks?
Correct.
Is there $100 bills in each one of these stacks? I'm looking at your IT guy.
It's a cartoon.
I mean, how can you say there's $100 bills in this when it's?
Hold on, let's ask him. What'd you say? The strip says there's $10,000. I don't know what $10,000 in a strip like that even looks like.
I do. I want a jackpot. I'm not kidding, Your Honor. I want a jackpot. They came out and gave me that. It's like 10 grand. I thought it'd be more. Somewhat pretty thin. I was up in,
Oh, so you're saying that is in fact what 10 grand looks like in a stack of hundreds?
You were up,
you
were up where?
At Lake Tahoe.
Keep going.
Yeah, I pay tax on it. It's like,
It's
I
okay.
won the lotto. People started coming out of the place, but they gave me that, and then it went like that.
What else did you do that night?
But seriously, that is true, Your Honor. I thought I'd share that with you.
I don't even know what you're talking, like, I don't know who they is in your scenario here,
Your Honor, this shows what the money is.
or what you received the money for. I don't even know if I
No,
wanna.
it's a jackpot. It's totally.
Oh, so you won something gambling and you got $10,000.
Look just like that. But that's what I'm saying, this is a representation of how much that money is, and that's a real problem for the defense, from a defense perspective, when people get up and ask for $35 million, because a lot of people don't have a concept of what that is.
I have a little problem with using cartoon to represent money too. I'm not calling, I mean, I think it's a good image, but it's an animation, right? Not pictures of any kind.
Your Honor, but they have animations all the time.
Right, it's just a
But let's look at the title of the slide. Go back to the title slide. Can you give me the big version of the slide again? What $50,000 looks like?
Right, I like it, like, if you've ever seen the slides talking about, the piles of rice, where they counted out like 3 grains of rice is this amount, and then they build the piles higher to show the difference, because the difference between $1 million and $1 billion is so vast that people can't wrap their brain around it. So that's the point here. It's trying to put the money, people don't have an innate sense of how much $1 million is to 50,000 or 35 million is to 50,000. It's just, it's not something that people have a good grasp on. So an animation just kind of lays that out to show.
I
them
understand what you wanna do. But I don't know how you don't get there with saying what the money, you can roughly say what the money can buy or put the money in perspective. I don't know how I feel about it being a cartoon when full disclosure, I don't know what $10,000 looks like in a sleeve like that. I don't know what $50,000 looks like in 5 sleeves like that. So I don't even know if that's an accurate representation of what it would look like when we're putting a slide above that says, this is what $50,000 looks like. Can I see the next slide again? And how did you count this out? You counted out each group of 10,000?
Yes, I did my.
It's just $100 bills.
Yeah, but you know what the impression this is giving, that like, if they issue an award that these plaintiffs are gonna be sitting on some pile of money. That's the impression that this gives, and I don't think that's,
Marty, we can't put up a picture of them sitting on a, the index fund. Gotta be a show of what it is, an argument down on demonstrative. I believe that's appropriate.
okay, anything else, council?
Come up with $35 million.
Yeah, I don't know how this doesn't go to, well, first of all, is sympathy. Second of all, I think this invokes the collectability instruction, because we don't know if we're gonna be able to collect that money or not, so they're making it look like we're gonna be able to collect that money. Third of all, I do think it's a golden rule violation because it distracts, and a jury nullification, it distracts the jury from the issues at hand. It is not what money looks like. It's what's the right amount of money to compensate for non-economic damages. So just on the pictures now, the picture of the money. Did I say jury nullification? I think it distracts from the issues at hand. Golden rule. That's what I got. It's prejudicial. I think it distracts from the issues. Sorry, Your Honor, that's it.
You guys wanna say anything more?
I just stand by that the take case in our view allows us to put the money in perspective.
Nothing more, okay. Okay. I'm just thinking about the image and I'll let you say this is a cartoon image of $50,000. Take the top off of it. Okay, it doesn't say this is what $50,000 looks like. Because none of us even know if that's what $50,000 actually looks like. You can say this is a cartoon image of $50,000. And then we've taken this image and now multiplied it by however many times you have to multiply it to get to 35 million. Okay, I'll let you do that. But you're not going to represent that this is actually what this money would look like. And if you try to represent that and they object, it's going to be sustained. Okay.
Understood.
The slide should not be up very long because I think there is a risk of them being overly prejudicial and a plea to emotions by putting them up too long. Okay, so they shouldn't be up too long. As far as the next slide, you can't base stuff on things that is not in any kind of evidence that would require an expert opinion. Okay, the value of a house in Nevada, we need an expert opinion on. Now, if you want to phrase it differently, like you said before, 70 homes.
How about this?
Could buy 70 homes at a $500,000 cost. Could pay for 350 all-inclusive cruises around the world at $100,000.
I have a different objection on the 70 homes, Your Honor.
Go ahead, what's your objection?
Well, the problem here is, one, it implicates that he's gonna get the money. Or some,
We've got an instruction though saying that's,
can I see it? I'm sorry, you took it down, I think. Second of all, I think it's conflating economic damages with non-economic damages. Non-economic damages have nothing to do with how many homes someone can buy, how many cruises they can go on. Non-economic damages are tethered to what has happened to the person, what they've suffered, how they've suffered. So I think this causes juror confusion.
okay,
And it's conflating two different issues, which is non-economic damages and economic damage. Now, if they want to put this in context of the economic damage that we're asking for, I think they could do that. But the problem is they don't seem to be objecting to our economic damages. So I don't think they can put this in context of what Eric could buy, or what Eric could do with the money, or what Anne Marie could do with the money, or what Eric Jr. could do with the money. The reasons are, A, they can't talk about what we should be able to do with the money, or what they should do with the money if they get it. B, it's causing juror confusion because it's mixing in non-economic damages and economic damages together. Sorry, Brad distracted me.
Pictures of money.
Got
I
it.
got a picture for you, Honor.
of $10,000.
Can you put it back up?
I need to edit my.
I understand, but I can't.
Well, maybe you should have put that in there.
Let's see what else. Go ahead.
I mean, Judge, if a juror sees even the first bullet point, how are they not confused that we're not somehow asking?
Don't you guys get to get up in rebuttal and say, they're actually seriously asking you to make the argument that we can trade human life for some of these things. You get to get up and make that argument, but they also get to be able to put the money in perspective. Now, whether you agree with their perspective or not, which I understand that you don't, and I understand that you won't, but they get to put it in perspective, because like I said, you got up and put in the perspective of comparing it to a $100 million painting. Okay, so you get to put it in perspective of however you're gonna put it in perspective. Now, I think you asked them all in selection what they thought about human life. I don't remember exactly what the responses were, but I'm gonna allow this. But again, if this starts to push toward where you are making a plea to sympathy, they're gonna be able to object. So I would be careful how long you leave some of this stuff up and how hard you hammer some of these points. And you're gonna get to say, we're talking about, let's talk about what we're thinking about replacing here, or what the money entails. You'll get to respond to it appropriately. Okay. So I'm gonna allow it, but within reason, and no numbers up there that are weird figments of whatever stats you found somewhere else that we haven't had anybody put into evidence here, okay? Like the cost of college, okay? Okay,
Can I finish my objection? Sorry.
yes, go ahead.
Just for the record.
Yeah.
The other part of the objection, Your Honor, is to talk about what they can or cannot do with the money. I don't think they're permitted to talk about what we should be able to do with the money or what we can do with the money. Otherwise, I could get people on the stand and talk about what we want to do with this money is we want to go cure hunger. So this jury should give a lot of money because we're not even going to use it for ourselves. We're going to use it to go cure hunger. So I think this is objectionable in numerous different ways that I mentioned, Your Honor.
Yeah, and let me pull up the slide I think he's referring to. And let me put this into perspective. So as we are filling out the verdict form and talking about damages, one of my arguments is going to be, we agree that, you know, these are what the damages are from Dr. Larmore. And let's talk about how do we kind of make this family whole here, you know, what if we buy a new house for Anne Marie and Eric? What if this happens and then you can award this amount for these types of items? And that gives you, that at least gives them a frame of reference for where we're coming from on some of these damages. But also I'm not arguing it in the sense of this is what the plaintiffs are gonna go do with the money. I'm arguing into the sense of this is what they can go do with the money. This is what we're agreeing that, hey, this is an amount and these are reasonable items that the family could use going forward. That's the context for this argument. I'm not saying that they should be limited
Yeah,
to these
but
items.
here's his counter argument to this, Lisa, what I just heard is, what if he gets up in his rebuttal and says, every penny you give us, we're gonna donate?
Greenpeace,
could.
Judge, Greenpeace.
He could.
This is completely improper, Your Honor. They can't do this. This isn't even consistent with the way it was done in Tate. This is different. The way it was done in Tate was not what
No,
the,
I agree. This slide is a different issue. Yeah, and I don't think you can get up and say, every penny you give us, we plan on donating. This slide isn't permitted. You can get up and discuss that they lost Eric, and as a result, we believe it's worth X amount of value, and because this is however many years he would have lived and the stuff he would have done, and this is what we think, but this is not a replacement for Eric. This is like other stuff. Am I missing something?
I mean, we're just trying to put.
Like nobody said that Eric was planning on buying them a house, right?
Right, so, well, Anne Marie has testified and they argued in closing, right, that Anne Marie has to live in the same house. Anne Marie drives by the same accident.
Yeah.
site. So that's where we were talking about the house. Getting her a new house, making sure. She also testified that she loves to visit family back east and in Puerto Rico. That's where the vacations. came
Yeah,
from.
but she's not asking that you pay for the vacation. She's asking for injury because Eric won't be with her through those things.
Right.
And those sums aren't paying for, I mean, at least what I understand, that's not talking about that. Like she's trying to, we're talking about two different things. It's one thing to say the value of 35 million is whatever it is, but it's another thing to say, okay, so instead of talking about what she actually lost with her husband, what if we bought her house instead? What if we bought her a car instead? What if we paid for vacations instead? Like, no, I don't think you can put this up. Okay, do you want to put anything else on the record about that?
no, Your Honor.
I need a few minutes to adjust my.
Okay,
slides.
are there any other slides that have issue?
Were there any others or?
I don't think so.
So I'm gonna let you put the money up,
Yes.
but you have to say it's an animation of 50 grand. Let's just go over this too. You'll get a few minutes to fix it.
Yeah.
You have to say it's an animation of 50 grand. I'm
Correct.
gonna let you put the other dollars up, but you say, if we took this animation and we multiplied it by whatever, this is what it would look like, okay?
Understand.
The next part where you start to talk about what you can buy with 35 million, or actually, I don't even want it to be what you can buy with 35 million. I want it to be putting 35 million into perspective, however you want to put it into perspective, but that's what you're doing. And then the next slide that you put up, that's not okay. The house, the vacations, no, because that's two different things. That's buying them items instead of talking about what they actually lost.
That's like.
And that does risk confusion.
Right, that's like does come way before that, but I understand the court's concern. I respectfully disagree. I think to take.
Of course.
Allows, but I
Okay.
will adjust the slide.
Okay, anything else before we bring them in?
I just need about 5 minutes.
Okay.
I just want to look over one more time if I may, Your Honor.
Yeah, go ahead. We'll go off the record. I'll walk out. I'll be right back in like 2 minutes.
Thank you.
So let my marshal know what our status is.
They think it was allowed, so if we could just go over it one more time, if you don't mind.
No, it's fine.
Thank you.
Let's go ahead on and do it.
One that you wanted to be less specific about.
I thought,
Okay,
I thought this was removed because A, we don't know the price of a cruise. B, this is mixing up. B, we're mixing up non-economic damages, economic damages. C, this is about what they could do with the money. I thought this all was disallowed, Your Honor.
well, okay, this was permitted to the extent that it's being used to talk about the value of 35 million. Not what your clients can use the money for, but the value of 35 million. If it goes beyond that, you can object. And I will sustain it if it goes beyond that, but they can use it to present the value of $35 million. $35 million is.
Well, shouldn't it not have the Eric there then? Because when it says Eric, it's in the context of the actual plaintiffs, not the context of, well, what the money can be, putting the money in context. Does that make sense?
I believe the way they got that number, and they can confirm, although I'm not doing the math on it, you should do the math on it to check and see if they're correct, if you're hesitant, but I believe the way they got the number is they looked at what Eric made annually, I believe, like what his total package annually was. And they divided 35 million by that.
Okay.
Okay,
I still think the problem with that, Your Honor, is putting in the context of what Eric can do with the money. And they can't talk about what the plaintiff should be able to do with the money. That's a wrong
But
standard.
they're not talking about Eric Junior here. They're talking about Eric Senior, I believe, right? This is what Eric, and I think maybe you should put Senior next to that. Would have had to, something like that. Okay, and look, you can get up and say that's not even a possibility, like you can respond to this within the rules as well, okay? But there, the other slide, the slide talking about, well, here's what we think would be reasonable, because this is what they could buy with it. That is asking them in that slide, instead of to compensate them for pain and suffering, it's basically giving them things, asking them to waive their pain and suffering. And I said that they need to take that one down because that was not an accurate representation of what was being compensated for in that slide. And I thought the risk of confusion and the overall prejudice of that was not appropriate. For a multitude of reasons, but frankly, I'm doing this on the fly. You guys have given me like a couple minutes of notice here, and I'm looking at these, not knowing that this is what I was gonna see ahead of time. And so I'm making the best rulings I can with what's in front of me. But like I said, some of these are being let in for, this is being let in for the limited purpose of saying what 35 million is.
Understood. Your Honor.
Okay.
I think I made my objections. I just want to make sure it's clear. It's golden rule, jury nullification, jury confusion. It's not being used to put the money in context, being used to put what the plaintiff or their family could do with the money and how long Eric Senior would have to work to get that money.
Okay, well, she's not gonna be allowed to make that argument. I told her, and I think she understood, actually, she confirmed she understood it. So I'm hoping she understood it, that it's gonna be able to be used to show what 35 million is.
Understood.
And I assume Mr. Johnson in his closing will also stick to the same parameters. I know we're not seeing a PowerPoint, but you understand that these rulings you're subject to as well, correct?
Yes, Your Honor.
Okay, thank you. Okay, let me know when you guys are ready.
Judge, there was a video that had it contained a social security number that defense pointed out to us, exhibit 8 of 3 copies of a flash drive, which is the identical exhibit,
Okay.
just the social that is cropped out. A copy has been given to.
You are both in
defense.
agreement. You can come up and
Yep.
change the book that goes to the jury is held with my clerk. So you can go ahead and come up and change it if everybody's in agreement.
Thank you.
And I'm understanding everybody's in agreement to the changes, Mr. Johnson. Okay, that's not,
Social needs to go out. Do they need to get this one too?
that's the jury books. They don't go back with, I mean, that's the witness books. They don't go back with the jury. The only ones that go back are the ones that my clerk is holding. She walks them back.
So just to be clear, they're able to fill the entire screen with all the cash, Your Honor? You're permitting that?
They're able to say, this is an animation of $50,000. If we were to take this animation and multiply it by whatever you need to multiply it by to get to 35 million, here's what it looks like. Okay, if that's accurate, and I'm taking their word for it, that's what that is. That's those 5 sets of $10,000 multiplied by however many times you need to multiply them to get to 35 million. Right?
That's my understanding. I'm trying to get that. 700.
Okay, are we ready to bring them in?
Yes.
Sure.
Everyone, please be seated. To counsel acknowledge the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you very much, ladies and gentlemen. Counsel, are you ready to do your closing argument?
Yes, Your Honor. Thank you.
Okay.
Is my microphone okay? Yes. All right, wonderful. All right, ladies and gentlemen, you've spent a lot of time with us the last couple of weeks, and again, I want to echo sentiments that we thank you very, very much for your time. This process truly can't happen without you, and I know you've heard that before, but hopefully not. Do you want to try it out? Oh. Now, ladies and gentlemen, we're at the end of this trial in which plaintiffs are now asking you to find liability and damages against Zaon Collins, stemming from that accident in December of 2020. They have asked you during their closing arguments to be the voice of the community and send a message. I pose this to you as we walk through the rest of our closing arguments today. Are we a community of vengeance, or are we a community of fairness and forgiveness? You have heard that there's so much anger wrapped up into this case. There's a lot of anger here. And it makes sense. Anger is one of the most well-known stages of grief. So we need to be able to remember that the system is built not upon anger or vengeance. The system is built upon the notion of fairness, equity, the scales of justice. So I want you to remember that by calling attention to Eric's human errors in his driving, we are not attacking him as a person. That's not what we are doing. We are not dragging him through the mud. We have not and will not say a bad word about Eric. He made a human judgment call and he made a human error. But what plaintiffs have tried to do from the onset of this trial is call your attention away from those mistakes. And the way that they've done that is to hold on to their anger and drag Zaon through the mud as retribution. In opening, plaintiffs' counsel made you several promises that Zaon was not being credible. He was not being truthful. We saw a bunch of true false slides. You didn't see those in closing. So for instance, let's just start with those. Zaon's speed. Plaintiff argued that Zaon lied about his speed because they showed a video of him in shock after a horrific crash. But as you know, sitting here for the past 2 weeks, we have never lied about Zaon's speed. It is what it is. We have embraced it. We've admitted it. It was unfortunate, and we wish Zaon had not sped that day, but that speed is what it is. We've never once during this trial said it was okay for Zaon to speed. The second issue they took was somehow Zaon did not know the speed limit on that road. Plaintiff took you through his deposition testimony, but failed to keep reading, letting the impression remain. We now know that Zaon clearly testified as to the speed limit in his deposition, and we do not need to accept cherry picking. Zaon was not honest about the speed of the car in front of him. That was the other claim they made, but plaintiff's own expert believes him.
So if he perceives that he was traveling the same speed of the lead vehicle, I believe him.
Okay. And the last thing that they tried to latch onto was Zaon traveling in the right lane. It was kind of an odd thing to fixate on. As the lanes opened from 1 lane to 2, Zaon's steering data shows that he made a lane change according to Mr. Terry. We could play that.
And again, remind me, Mr. Terry, of what degree are we talking that we would normally see on the steering input for just a simple lane change from the right lane to the left lane?
So we would see something, based on the ratio, we would see something around 20 to 30 degrees at the steering wheel.
20 to 30 degrees. Okay.
Or less.
Or less.
how low would it go? If you made a very slow lane change.
It could be a very small, it could be a very small angle. I don't know how to quantify it. Maybe let's 5 degrees or less.
5 degrees or less, and that could indicate a car began to make a lane change.
Yes, it's speed dependent on how much we turn, but yes.
Okay. So the faster the speed, maybe the lower the number.
Yes.
If we could go back to that chart, please. Zaon changed lanes, he was in the right lane. Then finally, Zaon was driving under the influence of marijuana. I'm gonna talk about this one more later, but suffice to say for now, plaintiffs attempt to destroy Zaon's credibility. They failed. Let's talk about the accident itself. Plaintiff discussed safety rules. Safety rules apply to Eric as well. Safety rules apply to everyone on the road. They do not only apply to Zaon. Now, I want to make something clear. Plaintiff said, well, we didn't have any experts. We don't need any. Nevada law says we don't need to have experts.
Nevada law, Your Honor.
It's true.
Yeah, but. Okay, so.
Strike, Your Honor.
Can I have counsel approach, please?